those of you who don't know us, my name is Bruce Robertson. With me is Alan Rycroft, and we'd like to welcome our Worklaw subscribers to this annual update. Normally we do this in person, and we're very sorry not to have met with our subscribers this year, but you understand under the COVID circumstances, we have had no option. We'd also like to welcome our people who are not yet Worklaw subscribers, and we'd like to welcome them to this workshop as well, and hope you enjoy the presentation. If you want to ask questions, there's a Q&A function at the bottom of your screens. Please post your questions, and Alan and I will deal with them as best we can at the end of the presentation, which should take about an hour. Alan, any points that I've left out?
I think that you don't need to take notes because we're going to send you a comprehensive summary of all the cases we talk about and other notes involved and the PowerPoint presentation. So rather just relax and know that the details are coming later.
All right, well, let's get going. We apologize again for the false start. But going back to the start of our presentation, firstly, we'd like to thank Trakiso. They are the dispute resolution agency. We work very closely with them and have a very good understanding with them. They've helped us set up this webinar. And just to put it out there up front, it was not their fault that there was no sound at the beginning. It was Alan's and my fault that the sound had not been turned on. Their details are on the screen. If you need an arbitrator, a mediator, a chairperson of an inquiry, they are the people to contact. They provide an excellent service. All right, we're going to cover during this presentation, firstly, unilateral wage cuts implemented by employers as a result of COVID-19. By unilateral, I mean without employees' consent. And we're going to talk about how legal this is and what the consequences are of going this route. Normally in our workshops, we cover a range of cases across all labor law themes. We've decided this year to focus specifically on unfair dismissal. And we're going to look at the key judgments over the last 18 months dealing with unfair dismissal. Just give me 1 second. That's the phone out of the way. All right, looking at unilateral wage cuts, there are two aspects that we focus on. Circumstances where the employees were legally barred from working. In other words, they weren't allowed to work under the disaster management regulations. And those circumstances where employees were actually allowed to work, but yet employers chose to implement unilateral wage cuts under these circumstances. Alan, take us through some of the judgments dealing with these issues.
I think we remember that as soon as lockdown level 5 took place, suddenly a new term was being used all over, force majeure, which is a French term to describe what in our law is called supervening impossibility of performance. And the question was, especially during lockdown level 5, where there was people weren't able to work, was the employer freed from the obligation to pay wages? Because, well, work couldn't be offered, work couldn't be done. Well, in one of the first cases to be decided, the Machazi judgment, it was confirmed that that was part of our law, that if the contract couldn't be performed, it was absolutely impossible, then the employer would be free from its obligation to pay wages. But this case was really invaluable for another reason entirely. The owner was the owner of several restaurants, and they decided that they wouldn't run the businesses because it wouldn't be profitable, but they could have done frozen meals, they could have operated at some level. And the judgment here, the High Court said, impossibility of performance will generally excuse performance of contracts, but just inconvenience or economic hardship does not make performance impossible. And that's the first lesson we've got to learn about the situation where performance, the defense of the possibility of performance is raised, that it's got to be really impossible, not just a choice you make because of economic hardship. Moving on to a situation where it is possible to work, but there's still a decision to cut wages. It's really interesting. The judgment we want to focus on is the Max Steel case. And the employer here very sort of ethically paid full wages during March and April of this year, but then the financial circumstances took over and they announced that there was going to be a 20% cut in pay going forward. And this was for people who were employed and even those who couldn't work, because remember in level 4, only 50% of workers could go back to the workplace. NUMSA wasn't happy with this because it hadn't been agreed and unilaterally imposed. The court, when it got to the court, said that while they could commend the employer for behaving as ethically as it could under the circumstances, wages were part of terms and conditions of employment and could not be changed unilaterally. So, Bruce, that's really, in a summary, what the cases have revealed about unilateral cuts.
Drawing some of the learnings from these judgments, and particularly this Max Steel judgment, it would seem to me that the employees in that situation were in two distinct circumstances. Those under which they in fact weren't entitled to any pay at all through impossibility of performance, and those employees who were working normally and were entitled to full pay.
Yeah.
And the employer failed to recognize the legal distinction between those two circumstances. I think it also highlights that judgment, that the need for employers to not act unilaterally as far as possible. You know, if you think about this case, the Max Steel case, had the employer said to NUMSA, look, you know, half the workforce won't be paid at all, the other half are entitled to full pay. How about if we reduce everybody's pay by a certain percentage? That might have been an agreed outcome. So be very careful about proceeding on a unilateral basis, and often these kind of compromises are an agreed alternative to a much harsher measure that would otherwise have been imposed.
Yeah. Bruce, I want to say that in our October newsletter, we are going to handle 2 more COVID cases, one on what is meaningful consultation in this context, and also a case dealing with where workers strike for fear of being infected with COVID. But that's coming in our October newsletter.
That should be out on Tuesday. For those of you who are Worklaw subscribers, we'll be covering those 2 judgments in the next newsletter. Just to move on then, having a look at some of the themes we're going to cover on unfair dismissal. We're going to cover procedural fairness issues, substantive fairness issues. We're going to look at specific forms of misconduct, and we're going to end off looking at some of the judgments. There's some quite important judgments dealing with dismissals for operational requirements. On procedural fairness, there are 3 issues that we're going to look at specifically. Firstly, for the employer, how specific do you have to be in drafting the charges for how much weight is attached to this? Secondly, the extent to which employees have the ability to lodge more than one dispute arising out of the same facts. Are they able to do this? Do both forums have jurisdiction? And thirdly, where an employer is taking the disciplinary action against an employee and that employee resigns with immediate effect, what is the implication of this on the ability of the employer to proceed with further action? So Alan, won't you take us through some of these judgments?
So on the first issue of how specific charges must be, we all know that in terms of the code of good practice on dismissal, the employer is obliged to give enough information to an employee so they can prepare for a hearing. There's a tendency, though, for employers to either use too lax language or too formal or too rigid in when they're formulating the charges. And in a recent case, EOH Ubuntu case, the charges involved theft, fraud, dishonesty. And at the disciplinary hearing, the chairperson felt that they couldn't establish intention, but nevertheless, the evidence was there that the person had behaved in a grossly negligent manner. So although they weren't charged with gross negligence, they were found guilty and dismissed for gross negligence. When this went to the CCMA, they said, no, this wasn't a fair dismissal because the employee wasn't charged with gross negligence. And in a very similar way, the Labour Court upheld that. But when it got to the Labour Appeal Court, there was a different approach entirely. The Labour Court recognised that employers are not lawyers and that there needs to be certain kind of room when it comes to formulating charges. They don't have to be expressed in legally perfect terms. And it is possible to find somebody guilty of a form of misconduct when the facts themselves suggest that. So there's a kind of a relaxation, as it were, of the need for very formal charges. So this is the EOH Ubuntu case. The charges must be specific enough for the employee to know what misconduct is alleged. And that's often done, I think, best, Bruce, I don't know if you agree, with a general description of the misconduct, not necessarily giving it a label. And because the second case, the second point the LAC said, the categorization by the employer of the misconduct is of less importance. Does this make it too risky for employees, do you think?
No, I don't think so. And I think the lessons here for employers, if you're chairing a disciplinary inquiry and it would appear to you that there's the possibility that based on the evidence that's been placed before you, the employee is guilty or has breached a particular rule which is slightly different to that described in the notice to attend the inquiry. I think one of the things that you could think of doing is alerting the employee or their union to this possibility that you're considering or contemplating an alternative charge, and allowing them to make representations to you how appropriate they feel that is. It then shows that you've applied your mind to it, you've given them a chance to have their say on that issue. The ad alteram partem principle has been applied. You may also then want to adjourn the inquiry to give them time to think about it and prepare any further arguments or to lead any further evidence that they wish to raise in connection with that amended charge. And so I think that's a practical way in which, as chairpersons, that you can deal with that.
All right, shall I go on, Bruce?
Yes.
So our second issue is having where an employee has a second shot, and it may be in another court. Let me tell you about the Archer case. The employee was a teacher and was dismissed. And this person went to the CCMA, and at that stage there was a technical hitch. The commissioner said, you have got to join the parents advisory group, whatever that group is called. And rather than amending things, the employee went then to the Labour Court and said he wasn't going on the basis of unfair dismissal. He was going on the basis of his cause of action, is the term. His cause of action was a breach of contract. So the employer obviously challenged the Labour Court's jurisdiction to hear the matter, saying, no, this has already gone to the CCMA. When it went to the Labour Appeal Court, the decision was that it was possible if there are two causes of action.
So there's a separate cause of action here.
So it could be unfair dismissal and unfair discrimination, or it could be, in this case, unfair dismissal and breach of contract. It is possible to bring a second case in a different forum.
So two causes of action could arise out of the same sets of facts.
Yeah, but I want to tell you about a second case, the Fairney case, which illustrates the opposite circumstances. In this case, the employee lodged a automatically unfair dismissal case at the CCMA, and shortly thereafter lodged an ordinary dismissal case at the CCMA. And in that case, the Labour Appeal Court said there was a single cause of action, which was unfair dismissal, challenging the fairness of the dismissal. And there wasn't a separate cause of action allowing the matter to be heard again.
Okay, let's just draw up these cases and look at the principles again, just to make sure that we understand them. Firstly, the Archer case. So where there can be then two claims arising out of the same cause of action, these can end up in separate forums, possibly arbitration and the labour courts. But in the Fairley case, where there's only one cause of action, there's one dispute, there should be only one set of proceedings. So the court seems to be highlighting that it's the unfairness of the dismissal that's referred, not the reasons for the dismissal.
Bruce, I also wanted to talk about, because there are these legitimate cases where there are two causes of action, unfair discrimination, unfair dismissal. What happens about compensation? The courts are clear that an employee can't double dip, they call it, get compensation in two different places. And the compensation awarded in the first forum is taken into account in the second.
All right, so the lessons there, if you feel that if you end up in two forums and you believe it's the same cause of action, you've got to oppose the second application on the basis of a lack of jurisdiction. If there are two causes of action, when the matter is dealt with and any award of compensation perhaps may have been awarded in a previous forum, you've got to bring that to the attention of the court to ensure that that previous compensation is taken into account in calculating any further compensation that might be payable to the employee under those circumstances.
Okay.
Moving on. What's the next issue that we're looking at?
Well, it's just, I think, Bruce, one of our most common helpline queries we get on Worklaw is about that immediate resignation, with a resignation with immediate effect. And
so an employer has instituted the disciplinary proceedings against an employee and he or she resigns with immediate effect.
Or even if the employee gets a whiff that there might be disciplinary inquiry coming and they resign. Now, before a recent case called Naidu's case, I would have, if I've been asked what's the law, I would have said that the employer retains jurisdiction to hold a disciplinary inquiry in the notice period, because in terms of the basic employment of the basic BCEA, there's the employment relationship lasts until the end of the notice period. Well, Naidu's case, which is fairly recent, said something quite different. And although it's also at Labour Court level, it is the most recent decision, so employers should be aware this could be used. In this case, the Labour Court said when an employee resigns with immediate effect, it means it precisely that. The employment relationship ends at that moment, and the employer can't then continue with the disciplinary inquiry. So that's quite a dramatic, so some employers really do need to have an institutional record of that there was misconduct, because it's not uncommon for a person who's resigned to rejoin an organization later. And it's can be quite important for an employer to have an institutional record.
Now, Alan, but there was a second part to the court's judgment.
Yeah, they recognized that the notice period was an obligation of the employee, and that if the employer wanted to retain the employee in the notice period, they had to go to court to get an order of specific performance, as it says on the slide there. Now, our courts are very reluctant to make an order of specific performance when there's an unwilling employee. And so I think this is pretty impractical.
Yeah, it seems to be a very impractical approach. The court saying that the employer has to proceed and attempt to get an order of specific performance from the courts, when, as Alan says, courts are very unlikely to have granted this. We are hoping, we were told that this case was being taken on appeal. We haven't heard or seen any judgment of the Labour Appeal Court on this. There may be some Standard Bank people who are watching this webinar, and perhaps if we've missed it, if there is some progress in the appeal process, perhaps you could say that to us in the Q&A function, and we can gladly share that with our subscribers. All right, moving on. As Alan said, we're covering material quite fast, but we will be sending you an update in the workbooks that we'll distribute after the workshop. Looking at some of the themes on unfair dismissal, substantive fairness, we're going to look at 4 specific areas. Firstly, is there a need for the employer to still lead evidence that there's been a breakdown in trust when misconduct occurs? Secondly, the reinstatement or reemployment are the primary remedies for unfair dismissal, but under what circumstances would this be impractical to impose this? Thirdly, there's an interesting judgment looking at ill health issues. The Code of Good Practice focuses primarily on employers' obligations. And this judgment is interesting because it highlights some of the employees' reciprocal obligations under these circumstances. And then there's a very interesting judgment looking at assessing performance during the probationary period and what the purpose of probation actually is. So yeah, let's move on. Alan, would you like to take us through some of these judgments?
Sure. So starting off with the element of proving that trust is broken down, I think we all look back to the EDCOM case, which is a Supreme Court of Appeal case, where despite being guilty of serious dishonesty, an employee was reinstated because the employer hadn't led any evidence that the relationship had broken down. And at the time, I felt very uneasy about that because I thought that some forms of misconduct are self-explanatory. Of course, the trust's broken down. And over the years, a couple of decisions have suggested that the employer doesn't have to always prove that the trust relationship's broken down. In a new case, AutoZone, the Labour Appeal Court applied its mind to this, and there was, again, serious misconduct. This person was charged with dishonesty, theft, misappropriation of company funds, and this dismissal was found to be fair by the arbitrator, but on review, the Labour Court said, the employer hadn't led any evidence at all that the relationship had broken down. When it got to the Labour Appeal Court, they said, actually, you must take evidence as a whole. You must look at the evidence as a whole, and you can assume that if certain misconduct has taken place, serious misconduct, that you can assume that, of course, the fundamental faith in the employee is gone. So that was the decision in AutoZone groups. I don't know if you want to put that slide up.
Do you want to wait and deal with the second case first, and then we'll look at both cases?
Okay, so in the second case, Kambushle, the Labour Court went on to develop slightly further principles on the same theme of establishing the relationship broke down. First principle they established was it's not necessary to lead evidence if the facts speak for themselves. Secondly, this is what you've got to take note of. If the only charge is that there's been a breakdown in the trust relationship, that's the only charge, then you've got to lead evidence that the trust relationship has broken down.
So just to describe that more fully, certain offences, certain things have happened. Individually, they may not be that serious on their own, but taken overall, there's just now been a breakdown in trust. So the actual charge or the allegation is the breakdown in trust, not the theft or the fraud or something else.
Right. Yeah, it's likely to be a long accumulation of incidents. And then the third principle from the Kambushle case is that even where there is evidence that has led to establish the breakdown of the trust relationship, it's up to the commissioner who will determine the appropriate sanction.
All right, so let's look at some of those judgments and just take you through the learnings there. The AutoZone case, Alan?
So if you're relying on irreparable damage to the employment relationship, then you must lead evidence unless it's apparent from the nature of the offence. And I think, let's be clear, this is stuff that, like in the Code of Good Practice, you're entitled to dismiss for the first offence, you know. And then secondly, where the offence shows dishonesty, it can be accepted that the employer will lose trust in the employee. So that's that case. In Kambushle, those are those three principles. When the facts speak for themselves, you're not obliged to lead evidence, but if the specific charge is break down a relationship, evidence must be led. And thirdly, even if evidence is led, the commissioner must determine whether the dismissal is appropriate.
All right. I mean, I suppose the learnings that I take out of these judgments is that if you end up in a circumstance where you haven't led evidence about a breakdown in trust, I think these judgments are useful to refer to the fact as to explain why you may not have led that evidence. Yeah. But at the back of my mind, I'm still saying maybe employers, if they wish to, should lead the evidence just to wear a belt and braces approach.
Yeah, but you can accept it's always going to be opinion evidence.
Yes, it is.
And so, yeah. But if it's for someone, the manager, to say that we can't trust this person anymore is probably worth doing.
Okay.
Yeah.
All right, moving on. As we said just now, reinstatement and reemployment are primary remedies for unfair dismissal. Alan, take us through what the Act says, yeah, and how this has now been applied by the courts.
For those of you who are around when the Labour Relations Act was drafted, it was quite a revolutionary thing when the Act made reinstatement the default remedy, the normal remedy. But in section 193 (2), the Act recognises there might be circumstances when reinstatement just isn't appropriate. The first is where the employee doesn't want it. The second one is what we want to look at today, is this: there are circumstances which would make continued employment, the employment relationship, intolerable. Thirdly, when it's reasonably impractical to reinstate, and fourthly, just when the only thing wrong is an unfair procedure. So the Act gives those four reasons when reinstatement need not take place. But I want to look at, tell you about a recent case, the Afghan case, where it was found that used the second one, when it wouldn't be reasonably practical. No, where the relationship would be intolerable. Here, there was like an employee from hell who the facts were seldom reported back to the supervisor, didn't take her seriously, bypassed her, didn't respect her as supervisor, didn't adhere to instructions, generally rude, and so on. So those were the facts. Now, the dismissal was found to be unfair, and so the commissioner was faced with this dilemma: what should the remedy be? Should there be reinstatement? But the commissioner said, well, it looks to me the relationship is broken down. I'm not going to, it'd be intolerable going forward. And so just ordered compensation. The Labour courts didn't like that decision and reinstated. At the Labour Appeal Court, the ruling came through quite clearly that the commissioner is entitled to look at the evidence as a whole, and there can be reasons to deviate from the standard norm of reinstatement. So in Afghan, the employee's conduct and the close working relationship acquired by the position, those two factors are really important. In this case, the employee's conduct was deplorable. And in fact, there was a close working relationship acquired with her supervisor. And so those two factors were seen by the Labour Appeal Court as sufficient to justify not reinstating.
Just the learnings from there, and I think many employers fail to do this. In an arbitration or at the Labour Court, they fail and forget to argue what we call in the alternative.
Yeah.
Most of the arguments would be based on the fact that the dismissal was fair, but I think you've got to cover your bases. And while not conceding that it was unfair, draw to the attention of the arbitrator or the court that in the event of the finding being that the dismissal was unfair, that reinstatement wouldn't be an appropriate remedy for these types of factors covered in this judgment.
Yeah, I think that's a good approach.
Yeah.
Yeah.
All right, moving on. What's the next issue, Alan?
The next issue is dismissal for ill health. And I'll be supposed to start as the code of good practice on dismissal, where you know that there are a number of employer obligations The employers got to investigate the extent of the injuries or ill health, possible alternatives, shorter dismissal, alternative employment, counselling, rehabilitation, and so on.
These are all outlined in the incapacity code of good practice.
Correct.
Yeah.
Now, there's just no mention at all of employees' obligations. And that's the highlight of a recent case in the Power Excel case. In this case, a clinical research nurse seemed to faint and hit her head after just 4 months of work. And she lost consciousness and had to get medical treatment. And then she was off work for the next 6 months. She's submitted different medical certificates from time to time, none of which were consistent. It's hard for the employer to get a real picture of what the issue was. The employee exhausted all their sick leave, their special leave, their annual leave. The employer stopped paying the salary but continued making contributions to the various funds. But they reached a point, after 9 months of the employee not showing up to work, the employer said, we want a medical report which contains the nature of the illness, the prospect of recovery, and whether and when the person would resume duties. This report was not submitted by the employee, and as well you can imagine, after 9 months of being away, she was dismissed at an incapacity hearing, which she did not attend, by the way. This dismissal was challenged to the CCMA, but the commissioner found the employer hadn't proved that the employee was incapable of performing her duties and reinstated her with 10 months back pay. Astonishing. The Labour courts dismissed the application for review, but it went on appeal to the Labour appeal courts. And this is where I think there's a really interesting judgment.
Do you want me to put it up?
I think so. And the idea is that the employer is not expected to tolerate prolonged absence from work. And as it says on the slide, the employer is not required to hold an incapacitated employee's position open indefinitely when there is a failure to provide reasons for this and the anticipated extent of the continued absence. And I think that the importance of this judgment is that it says that the incapacity investigation involves reciprocal duties. It's not only the employer trying to prove incapacity, it's also the employee providing information about the incapacity. So
okay.
I don't know about you, Bruce, I think it strikes me as being a fair and balanced judgment.
These are difficult cases, and I think it's a useful judgment.
Yeah.
All right, moving along. There are not many judgments dealing with probation and what well, Alan will outline to you. There's a particular description of an employer's obligations during probation, which is not particularly well worded, but Alan, explain to us how this has been applied.
Yeah, so I'm sure everyone will know that the Code of Good Practice and Dismissal has got a special section on probation, which recognizes that the employer is entitled to have a period in which to assess whether the employee is up to the job. The wording is unusual, but it says that if things are going wrong, there's as it were, like a lesser burden. It says the employer is able to accept reasons for dismissal that may be less compelling than would be the case in dismissals effected after the completion of the probationary period. So it's clumsy wording. It basically means that during the probationary period, if the wheels come off, the employer can accept less compelling reasons. It's a strange wording, but it was put to the test in a recent judgment in the Ubuntu Education Fund case. During this initial probationary period, the employee had 8 performance meetings, and it rapidly became clear that her appointment as a supply chain coordinator, she was completely out of her depth, didn't understand the work at all. And there was a poor performance hearing, and it became even clearer that she lacked even the basic understanding or the ability to carry forward in that job. She was dismissed. The employer uses evidence, the fact that the person who replaced her was able to acquire the performance standards within 2 weeks. So it was almost like evidence of how bad she was. But nevertheless, the employee, of course, went to the CCMA, and the arbitrator found the dismissal was unfair. And he rejected the performance appraisal evidence and saying there was no indication of how the points were done. And so he was quite a detail focused, and then she believed that the employee should have been retrained and even had responsibilities removed from her job description. She was reinstated, but it went on, of course, to the Labour Appeal Court. And there's a very good description in that judgment about the role of the probation period. And it's not only, the court said, to assess whether the person's up to the job, but something wider than that, whether there's fit into the position. And the court went on to say that arbitrators should be very reluctant to interfere with employers' decisions that the person hasn't met the required standards, because I think that's quite sensible to my mind, because otherwise the court would have to become the monitor of performance standards. So we have a judgment which I don't know.
All right. Let me bring it up, because there's some very useful learning points here, I think, from this judgment on probation. And there, as Alan has been saying, firstly, arbitrators should hesitate to interfere. And I think that you should argue that if you're dealing with a case of probation, draw the arbitrator or the court's attention to this Labour Appeal Court judgment. Secondly, very clearly, probation is also there to assess the suitability on matters of fit. Do you fit in with the organizational climate, etc.? Thirdly, that the employer is entitled to extend the probationary period to complete a performance appraisal. The person hasn't measured up during the 3 months or the 6 months, and so you extend it to give them a further period of appraisal.
Bruce, I just want to say one thing about that idea of fit. Of course, that's a bit dangerous. It can be a very subjective issue, because it doesn't really accommodate people who might be different.
Yes.
And so I think that if an employer uses that notion that wasn't corporate or institutional fit, they better have some criteria by which how you assess that.
Okay, good point. Yeah. And that last point, Alan, do you want to highlight that point? Because that came through in the judgment?
Oh, yes. Well, it goes really back to the arbitrator's judgment that which said the employer should have changed the job description. And this is saying the employer can't be expected to amend the requirements to accommodate the probationary employee.
All right, moving along, and we hope you're finding this useful.
Let me take you through the specific forms of misconduct which we want to deal with. The first one is quite a common problem, employees refusing to undergo a polygraph test. Secondly, we want to look at the difference between theft and possession, then derivative misconduct, then social media behavior, and finally, misconduct due to depression.
All right, looking at the first one.
So we all know that it's been said again and again that polygraph evidence is very unreliable evidence and can't be trusted by itself. But nevertheless, especially in industries where there is high security issues, there's often an obligation on employees to undergo a polygraph test.
In fact, it's written into people's contracts of employment.
And in a recent case called the Crossroads distribution case, there was a contractual obligation to undergo polygraph testing if required. Now, the facts of this case were really significant. Someone in the organization had changed what were high value goods to a status called low value goods, which has had really serious potential implications for the employer. SARS could have removed the employer's license. And so the employer was really shaken by this apparent fraud and asked all employees to undergo polygraph testing. and all except 4 agreed to undergo testing, and of those, those 4 were finally dismissed for failing to cooperate in the conducting of the investigation. 2 of the employees went to the CCMA, and they said, the CCMA said that it was unfair to dismiss for simply refusing to undergo a polygraph test. At the Labour Court, there was criticism of the Commissioner for failing to take into account how serious the facts were and what was at stake for the employer if it didn't get to the truth of the matter. The Labour Court did something which we kind of a bit uneasy about. The employer said it was justified because it wasn't really going to use that evidence alone. It was just narrowing its investigation, which I think in many ways was actually saying, if anybody failed the test, this is our man, you see. We think that it was a pity that the Labour Court didn't make reference to 2 previous decisions.
So just to confirm, the Labour Court confirmed the dismissal for failing to undergo the polygraph test.
Because the circumstances justified it.
Correct.
Yeah.
But did they take into account previous judgments?
No, they didn't. And there was an earlier judgment, which we'll show you in due course, the Inyati judgment, where the Labour Court did say, if it's a material term, to submit to a polygraph test, and if the employee refused to do so, this could be a breach of the contract, but it's a totally separate inquiry whether dismissal be fair or not. Okay, so in many ways it does tie in a little bit, but the far more significant judgment is the Gamalto judgment, which was very clear that it's almost as if you can't using a polygraph test as a fishing exercise. There has to be some separate evidence which leads you to believe that you need to be clear on particular employees.
And in fact, that Labour Appeal Court judgment was quite clear. It said even if there was an obligation under your contract of employment to undergo a polygraph test, it was only fair for the employer to exercise its right to make you do that where there was other evidence which tended to show that you may have been guilty of this offence.
Now, in Crossroads, they didn't have any other evidence, and so it does leave you with the real problem of what should they have done under the circumstances. But let's just look at this slide about the Crossroads. So the refusal to undertake a polygraph test when required may be serious and dismissible misconduct. And we say, please treat this with caution and read the Gamalto judgment, which you'll find on our site.
Yeah.
Bruce, is there anything else on that?
Well, that's a polite way of saying we think this judgment is wrong.
I think so. Or maybe it could have gone further.
Yeah. All right, moving on, Ellen.
All right, so the next thing is theft and possession. Now, it's common practice for employers to put in their disciplinary codes alternative charges, theft or unauthorized possession. What happens though if there's authorized possession? In this case, we're going to mention Aquarius Platinum. An engineer, so a senior employee, got permission to remove some metal scaffolding poles so he could mount a TV aerial at home. He didn't follow the correct procedures, but he nevertheless did get at least verbal permission to remove these. And look, the value of the poles was insignificant. 1,000 Rand, and they were going to be scrapped anyway. But they were never returned. And for some reason, it must have irked somebody at the employment because he got charged with theft. So he was dismissed for theft. When it came to the CCMA, the arbitrator was really very unhappy with the link between authorized borrowing, which is seems to be one concept, and theft, which is intentional, and the intention to deprive someone of their possession. And so the CCMA said, no, this doesn't look like theft, and so did the Labour Court. The Labour Appeal Court took a different decision, and they said conceptually, unauthorized borrowing can be very similar to theft, because in both cases, theft, you can see on the slide, theft is where a person deliberately deprives another of property permanently, and yet to borrow property and not return it, that's authorized borrowing, is also conceptually theft. And so the Labour Appeal Court found that the employee's dismissal was fair.
I think what's interesting, and we've seen it now in a couple of judgments that we've spoken about, is that the Labour Appeal Court appears to be taking quite a pragmatic view. And it's saying, ignore the technicalities of how you describe things, but what actually happened.
Yeah.
Let's look at the substance and not the form, as what, maybe that's a judgment that's still coming, where they say, don't look at the form, look at the substance.
Yeah.
So, I think this is a practical approach. If you borrow something and don't return it, well, at some stage, it constitutes theft.
Lots of people have got my books, Can we go on to Can we go on to derivative misconduct?
Yes. It's a difficult concept, this.
Yeah, so for those of you not familiar with the phrase derivative misconduct, it flows from the idea that the duty of good faith is actually fundamental to the employment relationship. Flowing out of your duty of good faith, it's said that there's an obligation to provide information to the employer of any misconduct which you might be aware of. Particularly, it most often happens in the context of like violent strikes. Now, we've been really uneasy about derivative misconduct because it seems to be pushing people too far. I don't know whether you feel this is...
Well, it's because it's mainly been applied in the strike context.
Yeah.
So Alan's on strike, he commits violence, burns machinery and plant and equipment. I do nothing. I observe Alan doing this, and I'm required to rat on Alan and disclose this to the employer. Alan lives next to me. He's much bigger than me. He's much stronger than me. Yeah. And he's got a violent temper. Am I going to survive if I describe Alan's misconduct to the employer? The
phrase that Bruce used just now, ratting on your colleagues, in fact was used not by us, but a judge in the Labour Appeal Court. The case I want to talk to you involved Dunlop, one of the Dunlop companies, who had to go through a month-long prolonged strike. And from the details in the judgment, one of the most vicious strikes I'd ever read about. Vehicles being burnt, houses being burnt, windows being smashed, people being stoned, and so on. Really terribly violent. So some employees were seen and identified and were dismissed for participating in violence. But there were lots of people who had taken part in these terrible activities who couldn't be identified. And the employer called on employees to come forward and identify them, and didn't. And it led to the dismissal of the entire workforce. So this whole issue of derivative misconduct came to the fore. In other words, there were people being dismissed because their misconduct was derived from them not ratting on their employees.
And this wound its way all the way to the Constitutional Court.
Well, I would say that first of all, in the Labour Appeal Court, the majority decision supported the idea that the duty of good faith required you as an employee to assist the employer. There was one minority judgment by Judge Savage, who she used the phrase, you can't expect people to rat on their colleagues. And that's what really was picked up by the Constitutional Court. This is really an important decision. And they have highlighted the fact that, yes, there might be obligations flowing from the duty to act in good faith, but it's a reciprocal duty.
Do you want me to put up this slide?
Yeah, I can do that, yeah.
Let's go through each of the learnings that have come out of the Constitutional Court's judgment on this.
So here they are. The Constitutional Court says that an employee's duty to disclose can never be unilateral. It must be accompanied by a reciprocal employer duty to protect the employee. And in the strike context, an employer would have to guarantee the employee's safety before expecting them to disclose information. Now, Bruce, I don't know whether you agree with me. I think this is almost the death of derivative misconduct, because I can see employers now being sued in negligence for failing to guarantee their employees' safety. You know, you've got quite a brave employer.
These are very difficult hurdles to overcome.
And there's some more others as well. So Bruce, why don't you look at the second?
It goes on, the judgment, to highlight if you are going to bring these allegations against an employee, this is what the Constitutional Court said you'd have to prove. Okay,
that you've got to prove that the employee was present when violence was committed. That's been highlighted because in the Labour Appeal Court's decision, it could say as long as you're likely to have been present. Now there's got to be you were present. And then you could have identified the perpetrators. I tell you, a bit nervous about the phrase could have identified the perpetrators, but you know the employer needed the information, you failed to disclose the information, and you didn't disclose it because you knew that the perpetrators were guilty of misconduct. So those things have got to be proved about every employee who you're charging with derivative misconduct.
Yeah. All right. I mean, I think that's a very useful judgment, and it's the first time that the Constitutional Court has dealt with the concept. So, I mean, I think it's obviously a very important judgment. I'm aware that time's moving on. We are going to carry on. There's some useful judgments on social media, and then moving on to retrenchment. So we'll try and speed up. We'll probably take another 10 to 15 minutes dealing with the rest of the judgments. I mean, I'm aware that we did begin a bit late because of the lack of sound to begin with. But Alan, moving then on, let's look at employees' use of social media. There have been so many cases where employees on a whim have posted something on Facebook or alternative social media forums, and they've lived to regret the consequences of their actions. Yeah. Take us through some of the recent judgments on this.
Yeah, there are two I want to draw to our attention. And just to say, haven't we all sent a WhatsApp message where the tone is wrong, the joke is a bit off? So this is easy to do, but in two different decisions, it had serious implications. In both cases, the employee was dismissed. In the one case, OneLogic's case, the employee sent to fellow employees on WhatsApp a meme image. Now, just to be quick about it, it showed a young white child holding a can of beer and smoking a cigar with a caption which said, "Growing up in the 80s, before all you pussies took over, may as well die young." All right. So it's kind of weird, and I think...
Okay, so just to highlight that there are no explicitly racist words or terms in that sentence.
Well, except it's a white child talking about life in the 1980s.
Yes.
So I accept that this happened in the United Kingdom. It would be, as the employee argued, a generational comment. It's a comment on the new generation, people who are born after the 80s, who are into political correctness. But what this case upheld the dismissal, saying that you've got to take these communications on social media in the context in which they sent. And the context in which this message was sent was South Africa in 2020, or a few years before that. And so the totality of all the circumstances must be taken into account to determine whether a communication that on the face of it appears neutral is in fact derogatory.
This fits in with a constitutional court, a fairly recent constitutional court, which is on Worklaw, where an irate person bursts into a meeting and says to the meeting or the health and safety officer, "You tell that black man to move his car." Now, is referring to someone as a black man, is that racist or not? Well, if it was used to distinguish someone wearing a blue overall or orange hair, and you're trying to distinguish one person from another, maybe it is descriptive in context. Yeah. But in the context of that case, the Constitutional Court said it was clearly racist, yeah, in the manner and tone in which, yeah, it was used.
So the lesson here, we all sense very dodgy stuff from time to time. Before you forward it, be very careful to think about the context, the fuller context in which people are going to read it. The second case, can I go into that?
Please.
That's an EdCon case, another EdCon case. And here you have an employee, well, got to stress, was on annual leave. So away from the office, on annual leave. They're watching carte blanche, and it's that moment in history when President Zuma replaces Finance Minister Nene with Minister Des van Rooyen, and it causes the employee to explode in racist and on Facebook in a really racist slur, and the person was dismissed. Well, there was quite a reaction. It got onto Twitter. And
just to add, the person was on leave.
Yeah.
And have you said that?
Yeah, they're on leave.
The person was on leave outside work.
Yeah, and that's on what that's the matter on which, and also the employee said, look, you couldn't identify me as the EdCon employee on Facebook, but it did actually get into the social media on Twitter that this was an EdCon employee, and the case turned on whether there was a link between this form of behaviour and the workplace. And the Labour Court said there was a link. So here's the principle: an employer can discipline an employee for out-of-work conduct, provided it establishes the necessary connection between the misconduct and its business. In this case, the connection was the fact that it brought the employer into disrepute.
Moving on, Alan. Misconduct and employee depression.
All right. So this time last year, when we did our presentations, we talked about a Janssen case where an employee at legal aid was dismissed for what appeared to be just depression. That's how it emerged to us at that stage. And there's now a Labour Appeal Court decision on the difference between depression, and the Labour Appeal Court recognizes there can be a kind of depression which affects not only your behavior, your state of mind, but also your will. And there can be depression which is unrelated to your misconduct. And the time prevents us going into this case in any great detail, but the Labour Appeal Court overturned the Labour Court's decision, saying that the employee's misconduct, which in this case was just going off work, giving no explanation to the employer, being rude to the employer, and so on. So there was that kind of misconduct, which in the Labour Court was excused because the person was depressed. Now the principle is employers have a duty to deal with depression sympathetically and should consider reasonable accommodation and alternatives to dismissal in incapacity procedures. But this is important: where depression may cause misconduct, dismissal may not be appropriate. But there are, is there another slide, Bruce, or not?
No, that's it.
Okay, this other part of the judgment is that there is a distinction between depression, where misconduct is not directly linked to depression. In this case, the Labour Court said the employee led no direct evidence that the misconduct was related to depression.
Yeah, I mean, I found this quite a clumsy judgment because it's clearly saying incapacity, depression is ill health, incapacity, and you've got to deal with it under that heading. There was no doubt that this employee was depressed, and yet I think it was he was dismissed for misconduct. And in this case, the Labour Appeal Court said that there was not sufficient evidence to show that the depression was such that it negated the misconduct.
The judgment's got some fancy terms of like cognitive ability and conative ability. So the judgment is very fair in going into the full nature of depression.
Okay.
Yeah.
All right, we've got 3 more areas to deal with, 3 more judgments on retrenchment, and they're important. So please hang in there. We've got 3 judgments to deal with, and we're going to deal with them one by one. The first judgment, Alan, on an obligation to consult with minority unions under retrenchment.
Yeah. I need at this stage to go to some of the text of the Labour Relations Act, section 189(1), which I'm sure most of you are familiar with. It's who the employer must consult with in a retrenchment exercise. And there's a hierarchy set out in section 189(1). First of all, it's any person who the employer is required to consult with in terms of a collective agreement. All right? And it says, failing which, you go down to the next level. Now, in this case, there was a collective agreement. And so the employer in the platinum industry didn't bother to consult with UMCU. And this went all the way to the Constitutional Court, which in the majority decision said that there was nothing unconstitutional with Section 189.1 in giving priority to a collective agreement, which said you only, in this case, only had to consult with NUM. So,
just to emphasize that whilst it was the majority judgment, there are 11 judges in the Concourt, and the score was 6-5. So there was a significant minority judgment as well.
Yeah, and so although the court is sort of recognizing that this hierarchy of consultation is appropriate, not fundamentally unconstitutional, I think we say that my view is that there's nothing stopping an employer consulting with minority unions.
I think, I mean, what if you were to read the judgment, and it's on Worklaw, it highlighted an interesting fact for me, which I hadn't thought of, which was that there's not necessarily a contradiction between consulting with all the unions, and if you don't reach agreement, then you strike a deal with the majority union, which then can be extended to cover all employees in the bargaining unit. But let's just pull up the principle then from that judgment.
Yeah, so you can see that the courts, the majority decision, that 189 consultation process is procedurally fair and constitutional. It does not require consultation outside the hierarchy. And then section 23(1)(d) of the LRA provides for the extension of collective agreements with a majority union. That's also not unconstitutional. That's an issue we haven't discussed until now, Bruce. But you can imagine UMCU was really annoyed to find that the collective agreement was extended to them without them being part of the negotiation. So it really touches on this whole issue of majoritarianism as being the guiding principle of collective bargaining in South Africa.
All right, the second to last issue highlights a real potential conflict in the Labour Relations Act. There's the ability to dismiss employees for operational requirements if you follow a fair procedure and if there's a fair reason. But on the other hand, it's automatically unfair to dismiss an employee for refusing to accept an employee's demand. So where an employer's demand. So where the employer is attempting to introduce changes as a means of saving and avoiding retrenchment, and those alternatives aren't accepted by the union or the employees, and the employer proceeds to retrench. Well, is it fair to retrench, or has this now constituted an automatically unfair termination of employment?
So this arose in a case of Aveng Trident Steel. After a year of consultations, I think the employer's patience snapped, and it informed NUMSA that the consultation process was exhausted, and it gave notice it would actually restructure according to the job descriptions they'd been consulting about. Employees refused to accept this, and they were dismissed for operational reasons. They, of course, alleged there was an automatically unfair dismissal. They had been fired simply because they wouldn't accept the employee's demand. By the time it got to the Labour Appeal Court, it was trying to work out whether or not they were dismissed for refusing to accept a demand, or were they dismissed for the employer's operational reasons. And it's a distinction between a legal causation and a factual causation. And maybe we can put up the slide here.
Put up the slide and have a look at it. Yeah.
So the Aveng Trident Steel case says the essential inquiry was the fundamental reason for dismissal, the refusal to accept the proposed changes in employment. And so the factual causation would the dismissal have occurred if the employees hadn't refused? And in this case, there was enough evidence to show that there would have been dismissals regardless. There was operational reasons for the dismissal. If there's no factual causation, you go into legal causation. Was the refusal the main or dominant cause of the dismissal? So this factual and legal causation is quite tricky conceptually. So I think because of time, can we ask you to read in our notes when you get the bundle of notes further on this issue?
But I think the key question there is the first point. What was the fundamental reason for the dismissal? Yeah. Were there circumstances which were heading towards a retrenchment, and were alternatives contemplated to avoid that? Or was this person dismissed because they refused to accept the alternatives?
All right, and so we go on to our final case, and it's asked the question, can you use retrenchment process to deal with incompatibility issues? This case involved two managers who just didn't get on, and the employer resorted to, I think, quite a sly solution. Rather than confronting the issue of incompatibility, it decided it said it was restructuring, and it was going to create, as it were, merge or consolidate the two posts, and invited the two managers to apply. And the person who didn't get it would be retrenched. So you can see the employer was slyly trying to use a retrenchment process to deal with an incompatibility process. And in fact, what the Labour Appeal Court held was that you can't use, it's procedurally unfair to use a retrenchment process when the correct procedure would have been meant to handle it as incompatibility. Yeah.
There are two further sort of aspects that come out from this judgment. Perhaps I'll put up the slide and take you through them, because I think these are important comments. I mean, the first point there is obvious. Alan's covered that, but I think the case is important because it does give you some guidelines to deal with incompatibility. And the second bullet point there talks about what the employer should do. It should propose action that can deal with it, but you've got to give the employer an opportunity to address the issues and to attempt to resolve the issues if they can be. And only then would it possibly be fair to terminate someone's employment for incompatibility as a form of incapacity. This judgment, this Labour Appeal Court judgment, is also interesting because it goes to what the purpose of compensation is, where a finding of procedural unfairness has been made. And there previous Labour Court judgments that say the exact opposite, that say that compensation is there for the employee to recover their financial loss occasioned by the unfairness of the dismissal. In this case, which is the Labour Appeal Court judgment, came out very clearly and said, no, not so. And it's a form of redress to compensate the employee for the unfairness, for the injury that he or she has suffered. And it lists the key factors to determine in arriving at the award for compensation. And they don't refer to the actual financial losses suffered by the employee. Comments on that, Al?
No, I think that's, I certainly agree with the basic decision that you shouldn't try and turn an incompatibility issue into a retrenchment issue. I think you should face the incompatibility, which of course is always messy, because the correct procedure there is to address it with the employee, give them a chance to improve. It's a lengthy process. And when you're dealing with managers, I think it's particularly difficult because you're expecting a certain kind of leadership of those managers.
Yeah.
Anyway, it's not easy.
All right, and we've tried to move as fast as we can, but to give you enough detail that we wanted to deal with. As we've said, Alan said earlier, we are going to send you a comprehensive workbook. It's about an 88-page workbook that covers all the content that we have covered, and we will also forward you a copy of the PowerPoint presentation that we used. As I said, those of you who may log off before the questions are asked and give our best attempt to answer them, please give us feedback on this workshop. You don't have to say that the first note of feedback is accepted, that we need to turn our mics on at the start of the, of the workshop. So we accept that. But if there's anything else that you particularly enjoyed or didn't like about the workshop, please give us feedback. All right, so moving on then to the questions that may have been posed, and we'll do our best to answer them.
Hi, Bruce. The first question was related to the charge sheet. If the categorization is less important, how about the date of the inquiry? So can the description be good enough where there's a wrong date cited on the charge sheet?
Kerith, I'm just going to move the speaker closer to us because we can't hear you that well. Just give me a moment.
Okay.
Okay, Kerith?
So the first question is from Kakuben, who it's related to the charge sheet that you dealt with earlier on in the presentation. If the categorization is less important, how about the date of the inquiry? Can the description be good enough if they've cited the wrong date?
Well, my view is that if
so just to repeat the question, I'm not sure if people have heard it. Alan?
If the categorization of the misconduct is not so important, what about an error like the date? Now, I think my answer would be this, that the employee's got to be given enough information to prepare. And if, for example, the date is just 1 day out or even a month out, but the employee clearly knows what incident it relates to, I think that that would not be a fatal flaw.
No.
But if a person, say an accountant, does certain work on a daily basis and the date on which this misconduct took place was crucial and the employee can't prepare without going to the work record or the work log of that day, I think it could be material.
Yeah, I think with all these circumstances, obviously the facts of each case is important, but go back to basics. Has the employee had a reasonable opportunity to prepare their case in response to the allegations? If they have, and not much goes on the fact whether it happened on the 18th of August or the 19th, then there's no prejudice to the employee at all. If there is prejudice, then as a chairperson, adjourn the inquiry, allow the employee a further opportunity to prepare their case in response to the amended facts which have now emerged. Okay.
Okay, then the next question is from Ian. Ian says that he took his employee crayfishing at Cape Vidal without a valid license. They were both caught and heavily fined. His employee lodged a grievance against him. And can he do this if the exercise was outside the company? He says that he may be dismissed because he's already on a final warning.
I know exactly who this is from. Alan, you can answer that.
Well, as I understand it, the question is, an employee takes his employer crayfishing at Cape Vidal without a valid license. They get caught. They're heavily fined. And now the employer is charging the employee with what? And this is an example of out-of-work conduct.
Exactly. I mean, this has, if you're an accountant or an accounts manager in a mining company in Richards Bay, close to where you are going on holiday the week after to next, Ian, then it has very little bearing on your work environment. So the first thing, if this is going to result in any form of disciplinary action, you would have to establish a link between what happened out of work and the person's work functions.
Okay, Kerith.
Brent's question is that with regards to immediate resignations, what about the judgment in the Kutsia versus Zaitz Mokai case? I'm not sure if I'm pronouncing that correctly, but from 2018.
Yeah, We didn't have, okay, the question is on that judgment, the Standard Bank judgment that we talked about that said the effective immediate resignation immediately cancels the employer's ability to bring further action against the employee unless you've gone to court to get a specific order. And the questioner referred to a previous Labour Court judgment that held the exact opposite. There wasn't time for us to canvass all the judgments that have dealt with that. And our notes in the workbook will do that, and it will include comment on the judgment that the questioner has now referred to. But the fact is, this judgment, this Standard Bank judgment, is the latest judgment on the issue, and it canvasses all those judgments and comes to a conclusion as to why it feels the previous judgments are not correct and why the approach adopted in the Standard Bank judgment is the correct approach. So because it's the latest Labour Court judgment on the issue, and because it canvasses all the previous judgments, even though we think it's wrong, that is the latest Labour Court ruling on this issue. And so if you were an arbitrator, you would probably have to apply the latest Labour Court's judgment on this ruling. Just on this issue again, we hope that that is going on appeal in the Labour Appeal Court, and we hope that we get, in our view, a more
practical,
appropriate judgment that emerges out of the Labour Appeal Court on this issue.
You know, it does strike me that there's nothing stopping an employer having an inquiry which is not a disciplinary inquiry and inviting the ex-employee who's now resigned with immediate effect, saying, we're going ahead and investigating this. We invite you to attend. We will make conclusions which will be kept in our records. It's not about dismissal, but it's a way in which I think the employer, which needs to have an institutional record of the misconduct, could do something.
And there would also be no harm in the employer investigating it themselves and then making a note on appropriate files that if this person ever were to attempt re-employment at any other branch of that organization anywhere else in the country, that they would be debarred from being contemplated for future employment. Kerith, next question.
Okay, the next one's from Simon. Performance in terms of theft is problematic. What if the employee intended to return the borrowed tool after a long time? It's not acceptable to the employer. So I suspect that's more of a statement or a response to the discussion you had.
No, Simon's raising then, well, what if the employee intended to return the borrowed item after a certain period of time? Alan, do you want to answer that?
Well, yes. In that judgment by Judge Sutherland, I think we tried to say how he saw there's no conceptual difference between authorized borrowing that carries on forever and theft. But one of the ingredients of theft, essential requirements, is, as Simon has said, intention. Now, if the employee can show, maybe through some kind of memos or emails sent, that there was always his intention to return it, I think that it would be difficult to find that was theft.
That could be different.
Yeah.
But I think that the judgment highlights, so if you allege something, you must prove it. And in this case, the court said, given the length of time, it was highly improbable that he intended to return these items. If he had intended doing it, why hadn't he done so? I can't recall the particular length of time, but the judge's conclusion was that at some stage, authorized borrowing, which is then not returned, becomes unauthorized. And the employee must have known that. And that effectively, under those facts, under those circumstances, constituted theft.
Okay.
Okay, the next question is from Lorato, who says that an HOD approved a payroll in which there was an error where the payroll's done by an outsourced company and paid the HOD a higher salary, which the HOD claims that the checking of the payroll is done by the officer. The HOD relies on the fact that the officer has verified that the payments are correct. Can this be considered as theft, as he failed to check if the officer's work was in order?
So, Lerato, I'm not sure if you will, sorry, there's a car going past. Lerato has outlined some quite complicated facts, but effectively there was an HOD who, in terms of a payroll, got paid higher than he or she ought to have been paid.
And that HOD authorized it.
He or she authorized it. It was meant to have been checked by someone else to confirm that it was correct, and does this constitute theft? Alan, you can answer.
Okay, here's my batches of this. I think the more senior the employee, the more you can expect. And I would think you would expect of a manager to recognize straight away that the salary was wrong, to pick up the error. There's one decision on Worklaw, which I can't recall of the name offhand, but where a managerial employee just refused to accept responsibility for something that was clearly an error. And I think in that case, there was a decision was that you can expect more from a managerial employee. So I think that's my thinking would go along those lines. I think authorizing means looking for any errors.
Yeah, and all these cases turn on the facts of each case, and what are the probabilities? Don't forget, if you're in a criminal charge in a criminal court, you've got to prove something beyond a reasonable doubt. So if there's a reasonable doubt, well, you get the benefit of the doubt. What we're dealing with in the employment environment is, on a balance of probabilities, what's the most likely probable course of action? And for the HOD, if he or she knew that there was a payroll, that their pay was incorrect, are they taking a chance? The fact that this has now been mistakenly approved by someone else, what are the probabilities? And just very briefly on the facts that Lerato outlined, I would say it seems to me highly probable that the HOD knew he or she was about to be paid or had been paid at an incorrect level.
But Bruce, I don't know about you, I would be wary of charging the person with theft. I would much rather in that kind of case go with gross negligence, because just in terms of the case we talked about that on the charges, this is a classic example where if you can't prove the definitional requirements of theft,
yes,
the person might be found to be unfairly dismissed.
And this might be one of those cases that we spoke about, where the conduct referred to has led to a total breakdown in trust.
Yeah.
And maybe one of the allegations is a breakdown in trust, which you would then need to lead the evidence about that. How can you trust an HOD who knowingly allows this payment to go through when he or she knew they were being paid at too high a level?
Yeah.
Gareth, next question.
Okay, Ingrid's asked if you could briefly deal with the secret ballot judgment.
Okay, we obviously hadn't prepared to deal with that, but
just get the question.
Sorry, the question is to deal with the secret ballot judgments. We wrote, and I actually wrote the article, so it should come back to me clearly, but it's not doing so at the moment. I wrote a recent newsflash article on this judgment, and effectively, do you want to come in? I'm
my mind's gone
battling, my
blank.
mind's gone blank, but effectively, as I recall it, the court overturned the previous judgment and said that you cannot require a union to undergo a secret ballot before, and you cannot challenge the failure of a union to hold a secret ballot in terms of its constitution as a means of challenging the protected nature of that strike. Ingrid, I will send you the Newsflash article, which will explain it to you in a much more coherent fashion than what I've just done.
Okay, Sastri has asked, can shift workers demand overtime to be part of their shifts?
Well, can shift workers demand overtime to be part of their shifts? Well, it would be a question of fact under the Basic Conditions of Employment Act, whether you're working within the ordinary hours of work or whether you're working overtime. So, I mean, to me, it's a matter of fact based on whether the shift cycle as implemented incorporates overtime or not. Can you demand overtime over and above your normal hours of work? Certainly not, unless there was an established practice or unless it was in terms of your contract of employment that you are obliged to work overtime and therefore by parallel obliged to be offered overtime work. But a demand for overtime in the absence of an obligation to have this would be a dispute of interest. It would be no different to a demand for a higher rate of pay.
Yeah, in case the question is about whether simply because the shift goes into normal after hours time, that implies there should be some kind of overtime rate. I think that, as Bruce said, you start with whether there's the right number of hours in terms of the Basic Conditions of Employment Act. Only if they are exceeded do you even start talking about overtime. Overtime doesn't relate to when you work. Yeah.
Okay. All right, we have a question from Mandla, who has asked that if you charge an employee with dishonesty for a very specific incident, but during the investigation they find out that the same offense was committed before, and the one that they've charged with, can you amend the charge sheet to include the other incidents, and what procedure needs to be followed?
So the question from Mandla goes to the ability to amend the charge sheet to incorporate a previous similar circumstance. You know, a typical lawyer's answer here is that all these cases depend on the facts of each case. One of the principles of natural justice is that you take action within a reasonable period of time of something having occurred. So if you are aware that a year ago this employee did something, you ignored it at the time, but now that it's happened again, you lump that previous charge in with the current offense to make it look more serious. Well, it's no longer fair to bring action against something that you knew about a year ago and you did nothing about. In fact, that will probably be used by the employee as a defense. Well, is this not condoned? Is it not accepted? I've done this before. No one said anything to me a year ago when I did exactly the same thing. However, if it's only just come to your attention in investigating this particular act of misconduct, you've now found out that the employee committed similar misconduct. You've gone into the audits and you've picked up that he or she, who's an audit manager, had made a similar false entry into the books a year ago. Certainly, you can include that in the charge sheet. This question might touch on how do you go about it.
It does. I think the question was more. It was also asking how do you maybe you start the disciplinary inquiry, and now this has come to light. What can you do? My feeling is that you could ask the chairperson to suspend the hearing and then amend it and seek permission to amend the charge sheet, give the person time to prepare on the extra charge.
Yeah, don't forget, in all these cases, there's procedural fairness, there's substantive fairness. And you, us as arbitrators, or you as chairpersons of inquiries, are the custodian of procedural fairness. So you've got to use a fair process in how you deal with those issues. And what would be the fair process under those circumstances? So as the chairperson, the management rep would be saying, we want to amend the charge to incorporate this previous issue that occurred 6 months ago. What do you do as the chairperson? Don't just make a ruling. Refer to the employee or their rep or the union rep and say, this has been now brought forward by the management rep. What's your view on it? Allow the alteram partem principle to be played out, the right to be heard. Hear both sides, and then make a decision, make a call on having heard the input from both parties. And under normal circumstances, you would probably grant the ability to do that, but attempt to address any prejudice that might be caused by, as Alan says, granting an adjournment, allowing them more time to prepare their case, perhaps call other witnesses that they would not otherwise have called, etc. And even the ability to recall previous witnesses who may have already given evidence on that issue.
Okay, the next question is from Daneo, who has asked that if an employee on their own accord indicates that they are incompatible with their boss, is this still considered incapacity? And would the employer need to institute an incapacity hearing?
You know, incompatibility, there are always two parts to the incompatibility. There's always two sides to those stories. And yes, there is an accepted hierarchical structure within an organization. There are managers who give instructions, and there are employees who have to implement those instructions. Alan, by the way, has written an interesting article in the latest newsletter, which is due out on Tuesday, where he unpacks the historic approach to the employment interaction between employers and employees. And he argues that the historical master and servant approach is not appropriate under the current times that we live in. So this is a plug for Alan's article. But those cases will go on the facts of each case. How reasonable have both parties been in how they've adopted and approached issues? In the judgment Alan talks about in Tuesday's newsletter, the manager turned his back on this employee as she was articulating a grievance where, in fact, unlawful conduct had been imposed on her. They had made deductions from her salary that were unlawful. And that case, the outcome of that case was clearly influenced by the unreasonable behavior of the manager and the unlawful instruction or action that had been taken against her.
I don't know if this query touches on how best an employee can deal with their incompatibility with the employer, with the manager. I think that touches on that. I think that a normal, this is a process kind of question, is if the employee filed a grievance and said, look, I can't get on with this manager, you know, to take on managers is a career limiting move. And I don't know whether, I think I would tend to go to HR and see if there's any facilitation that can take place to try and improve the relationship between manager and employee. The last thing the employee needs to do is start behaving like that toxic employee that we talked about in the one case. So I think it's very delicate how the aggrieved employee can get any change in behavior. I don't know, Bruce?
Yeah, look, I mean, these are difficult cases. I mean, and how do you lodge a grievance with the very manager that you are incompatible with? But yeah, I mean, I think that employees in those circumstances have got rights, and maybe they can even go sideways, as Alan says, to HR, or possibly even go above their immediate superior to seek help in addressing what they perceive to be extremely unfair treatment. Gareth,
Okay.
next question.
The next one is from Zonke, who's talking about a case of incapacity. There's an employee who agreed to be demoted due to his disability. An arbitrator made an order to reinstate the employee to his substantive position, even though he could no longer drive a Code 14 vehicle. The employer is currently considering a review. He goes on to say that the disability of an employee was that his one eye became blind and rendered unable to drive Code 14. And the Department of Transport declined his application to renew his license. And what is your views on this case?
So just to outline the question, someone was, there's a problem with their eyesight. The employee agrees to be demoted, but somehow this matter now finds itself as a dispute through to the CCMA, and the employee gets reinstated into their previous situation.
Well, I think this falls into the category of incapacity, where the person may not legally perform the work. The person now no longer has a license to drive. It's just an incapacity dismissal for me. And the person who was offered a demotion seems to have behaved very strangely. Rather than being grateful for the demotion and the continued job, I think now faces actually termination.
Yeah, look, I mean, it seems to be on those facts a very strange case, because if I cannot understand, well, go back to basic principles. You cannot amend someone's terms and conditions of employment unilaterally without their agreement. In this case, there appears to have been agreement, and it's confusing to understand why that agreement was not upheld and applied by the arbitrator. So, but let's look past that. In the absence of the demotion having been agreed, well, that was one of the options that the employer would have to have looked at as an alternative to more serious action. As Alan says, termination of employment on the basis of incapacity.
Okay, the next question is from Julian, who talks about lockdown disrupting normal work schedules. They have misconduct incidents or cases that occurred pre-lockdown and during the lockdown period or the lockdown levels that were interrupted due to people being unavailable as a result of COVID, quarantine, etc. The misconduct code guideline requires that action must be taken within 21 days. A number of those incidences are serious, and some people are on suspension due to the result of the seriousness.
Yeah, so I'm not sure if you've all heard the question. Your code requires you to take action within a certain period of time. During COVID, during the lockdown, it was not possible to comply with those time periods. How does that now leave the parties?
Well, the employer, it seems, could argue that it was impossible to comply because of lockdown, and therefore the obligation to react within 21 days falls away.
Absolutely.
And the employer must simply act within a reasonable period.
Yeah, you know, again, going back to basics with these things, what's fair, what's reasonable? If the employer could not possibly proceed, if there was a reasonable justification for not complying with those time periods, then I certainly as an arbitrator would overlook that, and I would ask what's fair and reasonable. Yeah. The alternative is you've got someone who's committed potentially serious misconduct, who then has no action taken against them purely because of a supervening impossibility, which was the intervening lockdown caused by COVID-19. So I think fairness applies both ways. It would be highly unfair on the employer to now not be able to take action as a result of that.
Yeah, I would open up the possibility for the chairperson to initially deal with any prejudice, because the cases which require quick disciplinary inquiries talk about prejudice to the employee by delay. So one of their witnesses resigns, dies, whatever, or is some evidence, people's memories fade after time. So there could conceivably be prejudice to the employee through the delay, because now it might be 5 months later. But if I was the chairperson or arbitrator, I would actually check if there's any prejudice.
Yeah, we highlighted just now procedural fairness, substantive fairness. If you're the chairperson, allow both parties to address you on that issue and assess whether any prejudice or the extent of it may have been caused to either party.
Okay, the next question is from Moses. It's around precautionary suspensions and holding a hearing. Is it unfair to suspend someone with full pay without a pre-suspension hearing or for a precautionary suspension?
Do you want to answer that?
Well, the Constitutional Court has made a ruling on this. Is it Long's case?
Yeah.
So I don't know the full citation, but it's Long's case, which if you just did a search on that name on Worklaw, you'd get taken to the Constitutional Court decision. I don't really agree with this decision. They say that the pre-disciplinary suspension, the precautionary suspension, is not a disciplinary process. I have difficulty accepting that, but the Constitutional Court has said it, so that they're wiser than me, and they say, so you don't have to have a hearing. But the court did say that there can't be prejudice to the employee, which in other words, you must keep on paying them their full salary. So otherwise, if they were prejudiced in this period of suspension, then it would turn into a disciplinary process. So I think if a person is suspended without hearing, but on full pay, I think that complies with the Constitutional Court's decision.
Yeah, so we can't move away from the fact that the Concord has ruled on this matter. Our practical advice to employers is that, put yourself in the shoes of an employee, because, their reputation is seriously tarnished by being suspended on full pay. Other employees say there's no smoke without fire. He or she's been suspended on allegations of sexual harassment or some serious issues. We think, well, firstly, those charges may or may not be subsequently proved. You've got to have this person back at work, functioning as someone who's working and operating effectively in the work environment. It would have been much fairer to have allowed the person their say before you suspend them. What would be the fair thing to have done is to call me in and say, look, these allegations have arisen. We have to deal with them. We have to remove you from the workplace while this gets investigated. What's your comment on that? And allow me to have my say and say, listen, if you do that, in my ability to ever come back here and to be and to manage people under me, have a look at this aspect, that aspect, at least you're informed then as management by the views of both parties before you then take the decision to suspend. So that Constitutional Court judgment is there. We can't move away from it. Alan and I don't particularly like it, but we're trying to advocate a much more fair, perhaps less legalistic approach to how you should deal with it.
Yeah, it's also worth remembering that the Labour Appeal Court has ruled that there are very limited reasons why you should suspend people prior to the hearing. One is where they might tamper with the witness or the evidence, or they might there might be the risk they might repeat the misconduct. Very limited grounds or reasons for suspending. But I think that there's another reason why employers are very keen to suspend is because they don't want the employee to argue at a later stage that, oh, you knew I was charged with these things, but you let me carry on working. Therefore, the relationship hasn't broken down. So employers are in a tight fix. They might face that kind of argument, and therefore they suspend. At the same time, the Labour Appeal Court has said, oh, there are very limited reasons when you should suspend.
Gareth, how are we doing with the questions?
We still have quite a number of questions and they keep coming in, Bruce. I'm not sure how many more you would like to continue, if you'd like to continue.
I mean, if they, we have no idea how many people are still there and still watching.
There's still a lot of people online. We
are happy to continue answering questions.
I do have a plane to catch though later on.
Okay, you've got a question from Andrew, which relates to temporary disability. He wants to know what is an appropriate time to terminate employment. Is it when the insurer advises a company to do so, or can a company terminate employment following an incapacity process?
Should you want me to go?
Yeah.
You know, these issues around incapacity and disability are difficult cases, and as always they turn on the facts of each case. Firstly, there's no written time period that you can refer to in an act or a code of good practice, and you've got to deal with the effects of each case. Can I also highlight that there are two issues which are often mixed and muddled, but which legally are two very separate issues. The one is the employee able to be medically boarded through the insurance company or the provident fund or the pension fund? And that's an interaction legally between the pension fund or the provident fund or the insurance company and the employee. Separate from that, and irrespective of the conclusions that entity, that fund or insurance company comes to, separate from that is the employment contract between the parties, where under incapacity, ill health, you look at the factors which are listed in the Code of Good Practice, and they involve, in summary, looking at, is this a temporary issue or a permanent issue? If it's temporary and the employee's got TB and he or she will be back at work within 3 months, can you accommodate that? Can you employ someone else in their place, pending the person's return to work, etc.? If it's a permanent issue, the person has got diabetes and they've had their legs amputated, and this is now a permanent issue. How can you adapt the job, the person's functions? Can you provide them with a chair? Are there alternative things can you take away certain functions? How do you address it as an alternative to a dismissal? Okay, and it's only when those alternatives have been explored and found to be inappropriate or perhaps too expensive. You've got a 5-year lease on your business and it's on the 5th floor of a building and there's no lift, but then you could help people carry the person up the stairs. Sorry, I'm getting into too many details here, but you see what I'm saying. Look at the facts of each case, explore alternatives, and within reasonable time frames, and see what's possible. If it's not possible, then you justify it in terminating for incapacity, ill health.
Yeah, the question was specific. This was temporary incapacity, and that always sends up a red flag that it'll have to be very, very special circumstances to terminate temporary incapacity.
Yeah.
Yeah.
As always, Alan goes specifically to the facts, and I ramble on in broad principles. Okay.
The next question is from Nozipo. This is relating to a disciplinary inquiry that has started, where the employer has started leading evidence, or they're at the evidence stage, but the employer realizes that they lack sufficient evidence, does not stipulate the reasons to the parties, but then later wants to or decides to use similar charges and recharge the employee, bring in new evidence. Okay,
do you want to deal with it? So the question is, you brought charges against an employee, you haven't led enough evidence, you presumably the employee's found not guilty or those charges don't stick. Can you resurface those charges at a later date and recharge the employee?
I think the crucial issue is whether in that first disciplinary inquiry, whether it reached a conclusion, whether the chairperson found the person not guilty. If that person has been found not guilty, I think a subsequent recharging would have to be done only under the most extraordinary circumstances, and there must be very serious misconduct. So if that first hearing reaches a conclusion and they're found not guilty because of lack of evidence, that's it. I mean, there's this legal term, res judicata, the matter's been settled. But if the employer withdraws the charges because it realizes there's not enough evidence, I think that makes it easier to start the process again.
I think it also goes to the reason why that initial evidence wasn't available. If for example, that evidence was out there, but you just didn't bother to collect the evidence, it was there, it could have been known to you, then clearly, as Alan says, res judicata, you can't bring that case again later. Because you didn't do a good job on the first inquiry, you can't now try and do a better job in the second inquiry. However, if you charge an employee with certain misconduct, and the matter was concluded, the person was found not guilty, but now new evidence comes to light at a later stage. I mean, there's a case on the Worklaw site, I can't remember the name of it, but the facts are interesting. This employee was charged with fraud, I think, and theft. She was found not guilty. She then broke up, or she then got divorced from her husband. And her husband later, sometime later, came back and produced all the evidence. And for the first time, the employer now had this additional evidence. If new evidence has arisen, which was not available to you previously, that could then provide the basis of a fresh charge.
The real lesson of the case is not to go through a messy divorce.
Yeah, don't get divorced when your spouse has dirt on you.
Okay, the next
Kira?
question is about an employee who has absconded, has moved house and does not provide the employer with a new address. The employer tries all avenues to find the employee and even calls are not going through. Can the employer go ahead and charge the employee in the absence of serving any notification to that employee? And possibly proceed with a hearing and dismiss?
So can the employer hold an inquiry in the absence of the employee when they fail to get hold of the employee, he or she's changed their address, they've moved, they can't be located? How does the employer deal with this?
Well, I think in most abscondment cases, the employee is missing. The employer is forced, because the employee has absconded, to go ahead with the evidence. Well, the basic evidence is the employee hasn't turned up at work. So there's a procedural issue. Was the person, the employee, given the chance to defend this? I think it's a Suvatsi Chrome case, which they found it to be fair that the employee's disciplinary code allowed for the employee to be reinstated if they arrived at a reasonable time and furnished reasons why they had been absent. But that was a particular code. But my feeling is if the employee's made every attempt to... The employer's made every attempt to make contact, and there's no results, and the employee themselves has made no effort, I think that actually I would say it's procedurally fair to continue in the absence of the employee and have the evidence presented of abscondment.
Yeah, certainly you're entitled to proceed then in the absence of the employee. Just be careful though. Many employers take the view that, well, the employee has dismissed themselves. They haven't come back to work. And they just write the person off in their books as no longer being an employee. if they then taken to the CCMA, there's a need to prove procedural fairness, substantive fairness. So on the procedural fairness side, where's your evidence of attempting to hold some form of inquiry to investigate the matter before you terminated the person's employment? So even though it may sound academic and a bit sort of absurd to some extent, have notes of the day on which you held an inquiry, call a shop steward to attend the inquiry, say, these are the lengths we've gone to try to get hold of this employee. We've been to their last 4 addresses, we've sent them WhatsApps, we've sent them emails, we've spoken to other employees, we've put out a brief in the workplace to say, does anyone know of the whereabouts of this particular employee, and lead that evidence, and then proceed and to take the decision to terminate the person's employment. Gareth?
Okay, the next question is, what recourse does an employer have if the employees or the union renegades on a settlement agreement?
Okay, what recourse does the employer have, or does in fact either party have, if the other party reneges on a settlement agreement?
If the settlement agreement was in the context of a CCMA case, then that settlement agreement can be made an arbitration award and can be enforced. If the settlement agreement is reached in private negotiations, it's more tricky, and it's really like a breach of a contract, isn't it?
Yeah.
So I don't know if you have any wisdom on that.
No, I think, I mean, Alan's highlighted the 2 differences very clearly, I think. So those are the 2 circumstances, and those would be your 2 remedies.
But I mean, I think it's worth just, so here the difficulty, it's not the employer sort of reneging, it's the employee reneging. So let's imagine the employee is still in the workplace. It's not a discipline. It's not a disciplinary issue. It's an inconvenience.
Well, I mean, it depends on the facts of each case. It's possible that there was some issue and there was an agreement reached upon, and I would think then if that employee is still working in the workplace, the employer can give reasonable instructions to comply with the agreement.
Yeah.
And then I think you could then take action against the employee for failing to comply with a reasonable instruction.
Okay, that's good. Yeah.
Gareth?
Dumasani has asked, can the employer terminate the contract of employment without holding an inquiry in the case of abscondment? And does the notion of repudiation of contracts come into play?
Can the employer, in the case of abscondment, terminate the contract without holding an inquiry?
In the public sector, there seems to be a deeming provision that if you are away for 21 days, you are deemed to be dismissed. But not many private sector.
And that's in a statute.
Yeah, it applies to teachers and well, public servants generally, I think.
Okay. Yeah.
But in the private sector, that wouldn't be the case. And I still think, as Bruce said earlier, there's got to be some kind of procedure that you can say there was, attempts to contact the person. There was a hearing of sorts. A hearing might only be really 5 minutes.
Correct.
It's all, but I think there's got to be a paper record that there was an attempt to contact the person and they couldn't be found, and then evidence that the person had been missing for a certain period in the workplace. Yeah. So I think that just to cover myself, I would always go through that moment of having a 5-minute hearing, inquiry. Yeah.
The alternative is to argue that there wasn't a dismissal at all, and this was abscondment, and there was effectively a legal termination of the contract by the employee, and it gets you into quite complex legal arguments.
But I think Dumasani might be correct that in law, the employee can resile unilaterally.
Yeah.
But I think, as Bruce says, far rather go the sort of the brief hearing route.
Kerith, are you there?
Yes, the next question is from Leonie. She asks, what is the criteria to prove negligence? Is it similar to theft, or do you need to prove the intention to cause damage to the employer?
Right. The question is about how do you prove negligence? Alan, perhaps you can answer that and distinguish between negligence and gross negligence.
So it's really important that our cases have always distinguished between negligence and gross negligence. So negligence is where somebody knows what the standards or the job requirements are and inexplicably departs from those standards. And you can't explain it because they've done the job before correctly and now they've just departed from it. So that's negligence. And what you'd have to establish is the person knew the rules or knew the standards and didn't comply with them. Negligence itself is seldom grounds for dismissal by itself. But gross negligence is all that, what I've said before, but actually a careless disregard for the consequences, often leading to lack of safety, risking huge financial loss for the employer. It's just a matter of degree that the person knew the standards but acted with willful disregard.
Yeah.
Is that right?
Yeah, it's the extent of the negligence and its consequences were much more severe.
And dismissal usually follows gross negligence.
Correct.
Yeah.
Kerith?
Okay, the next question is from Larato. Her company has a contractor that employs its employees based on the actual contract that they have with the company. In this scenario, the contractor renews the contract of employment to its employees on a yearly basis, as per their contract with the company, and also has a probation period in which this instance it decided not to renew 4 of its employees for various reasons, of what it considered to be misconduct and not due to performance. Is that dismissal fair or unfair?
So Larato is asking, you've got what sound like to be fixed term contracts of employment for a year. Some are renewed, some are not. Is this fair?
I think the answer about fixed term contracts, there's no obligation to renew a fixed term contract unless there is a reasonable expectation of renewal. If you look at the definition in section 186 of the LRA, what dismissal is, one of the defining characteristics is where a person has a reasonable expectation of renewal and it's not renewed. So, but I think a reasonable expectation is only acquired after 2 renewals.
Well,
it's not said anywhere, but
it depends on the facts in each case.
Yeah. So I think I would say that if there's only been 2 annual renewals, I would say it's hard to say that there's a legitimate or reasonable expectation of renewal.
Well, I think it's going to be. I'm not sure if I agree with that number because I think a manager can, even after 1 contract, if the manager is saying to you, we need you, and I know your contract only extends till December, but we'll need you to carry on working in your job in the new year. I think even under those circumstances, there can be a reasonable expectation of a renewal. But going back to basics here, the expiry of a fixed term contract is under normal circumstances not a dismissal. So if you are challenged, firstly, your defense will be, well, we haven't dismissed you, it was merely the expiry of a fixed term contract. If you allege something, you must prove it. If the employee is saying he or she had a reasonable expectation of renewal, then he or she has to prove that based on the evidence and facts of each case. The question you asked was interesting. Firstly, let's put aside that section 189B, which deals with fixed-term contracts of employees earning less than the prescribed amount under the BCA, and the limitation on the use of fixed-term contracts. I'm not going to deal with that. Let's put that to one side. But where there are 5 people, and 3 of them have had their contracts renewed and 2 haven't, is there a reasonable expectation of the 2 as to what factors justified them not being re-employed on a further fixed-term contract? Do you want to answer that question, Alan? Do you have,
I'm not sure.
Because I think that starts to paint, under the facts of that case, a reasonable expectation of renewal. And there, I think that opens the door to those 2 employees where all the others had their contracts extended. Those 2 employees didn't have their contracts extended. There'd have to be a reasonable justification for why those 2 employees didn't have their contracts extended. And you'd have to leave, that would then open the door, I think, to their not being re-employed as potentially being an unfair dismissal. And you'd have to go and look at the facts of that case as whether there was a reasonable justification for the employer in that instance not extending their 2 contracts. And the fact that they were guilty of misconduct, etc., may well be a reasonable justification why those 2 employees didn't have their contracts extended.
Yeah. Just this is not exactly my point, but we got a case in the last year which we wrote about, where there was a dismissal in the strike context, and the employer chose to simply re-employ non-union members. Do you remember this case? And there was strike dismissals, and the court said the selective re-employment was another dismissal. And so what happens subsequently can become a dismissal, just the act of selectively. But I'm not.
Well, if you look at the definition of a dismissal, the selective re-employment constitutes a dismissal.
Yeah. So, yeah, it's not exactly on point, but it's.
Well, I think it certainly applies.
Yeah.
Yes, Karen.
Okay, the next question's from Moses. It's also got to do with incapacity. An employee develops medical conditions that limits their capacity to perform duties, such as being a driver and being unable to offload stuff from the bakkie due to backache. The company makes some effort to find alternative work accommodations, but is unsuccessful. How far is a company required to go to accommodate that employee in a case that's not connected to injury that was on duty or disease contracted on duty?
So how far, Moses has asked, does an employer have to go to accommodate an injured employee, particularly when that injury didn't arise in the course and scope of employment? But I think that the first point to make is that the Code of Good Practice does make it clear that if that injury had arisen in the course and scope of employment, it does place a much higher obligation on the employer to attempt to accommodate the employee. But, again, these cases, Alan, go on the facts of each case.
Yeah.
You've got to show an attempt to reasonably accommodate this person. Can you give them a different job? Are there different jobs available? And the facts will show that you might have employed someone in an alternative job very recently that this person could have done. Could you adapt their duties, taking away certain duties to enable the employee to do 80%, 85% of their normal duties, and reallocate the other 15% of their duties to other people? So it's all what's fair, what's reasonable, and the facts of each case is going to determine that. I'm not sure if we can take it any further.
Well, except just one caution. This is one of those cases where you can move from incapacity to disability, and it might trigger the disability code. But even in the disability code, there's obligations on the employer to accommodate, to make changes and so on. But it goes on to the point where I get the burden on the employer can terminate. So you do reach a point where, having tried to find alternative work for this person whose backache is there, to where the employer is entitled to end it.
Yeah, I mean, to give you perhaps an absurd example, but just to make the point, if there was a piece of equipment that you could buy for 250,000 Rand that would then enable that individual employee to perform their functions, it's not expected of the employer to spend the 250,000 Rand on buying that individual piece of equipment to accommodate. That would be unreasonable. That would be too much of a burden on the employer. All right, moving on.
That was the last question, Bruce. There's been a lot of comments coming through with thank yous. I've got from Monty, Tanya, Brent, Sastri, Ingrid. Andrew says he would be lost without you, and beware of the crayfish that creep in the night. So lots of thank yous coming through.
Yeah, just an interesting story for the rest of you. I'm going on a holiday the week after next with that person to Cape Vidal. So that was the background. We'll be doing some crayfishing at Cape Vidal.
I hope with a license.
I hope we both got licenses. It was at that point that the witness became evasive. Yeah. But firstly, Kira, thank you for your involvement. We couldn't have done this without you, and we so appreciate your help and your involvement. To all our subscribers out there who might still be watching, thank you for your continued support of Worklaw. Thanks for taking part in this webinar. Please give us feedback as to what you thought of it, how we could improve on it in future, whether this is a forum that we should use going forward. And we do appreciate your continued support of Worklaw. And just to make the point again, we are going to be sending you a very comprehensive workbook that covers all the issues that we've dealt with during the webinar. Thank you.
Thank you.
Thanks, Alan.
Cheers. Thanks, Bruce.
Cheers. Bye-bye, Gareth.